Welcome to this training on the Consumer Contracts Regulations 2013 that come into effect on the 13th of June 2014. If you're selling online to consumers, not businesses, you need to know this. Now, the main changes are the right to cancel, information requirements and additional charges, and we're going to be covering those in the 3 videos. And there are potentially disastrous consequences if you don't comply. My name is Suzanne Dibble and I am a multi-award winning business law expert. I used to work in the largest law firm in the world and with Richard Branson, and I've been runner-up twice in 2 national awards for Best Solicitor of the Year. If you want to know more about me, then go to my website suzannedibble.com and read more about my experience and how I can help you. So the cooling off period has been extended from 7 days to 14 days. And if you don't make this clear in your terms and conditions, then your customer can return goods for up to 12 months after their order. And obviously, if you have fast-moving product lines or stock issues, then that is going to be hugely detrimental to your business. So you must make this clear in your terms of business. Now, you can provide the customer with a form of cancellation, and that's what I recommend that you do. And they can use that to actually cancel the contract. However, if a customer makes a clear statement that they want to cancel, this need not be in writing. So if they phone you up and tell you that they want to cancel, then you must accept that. Once the customer has made a clear statement that they want to cancel, then the customer must return the goods to you within 14 days. And again, this is something that you should include in your terms and conditions to make that clear. There are some exceptions to the right to cancel. And for example, goods which deteriorate rapidly, such as foodstuffs, contracts that are concluded at a public auction, but note that that does not include eBay, and goods that are made to specification or are clearly personalised. Now, in terms of what is made to specification and clearly personalised, let me give you some examples. So if you were to order a sofa and you chose certain finishes from a product range, so that you had a teak finish with a certain colour cushion, then that would not be personalised sufficiently for you to lose the right, your customer to lose the right to cancel. If, however, your customer had asked for a finish outside of your product range and you had done that as a special order for them, then they would lose the right to cancel because you would not be able to necessarily resell those goods to another customer. Another example with a football shirt, if a father had ordered a football shirt for his son that had the son's name across the back, then that would be personalised to the extent that that customer would lose the right to cancel, because you might not be able to resell that particular football shirt with that name on. If, however, they had merely chosen the name Rooney across the back of the shirt in Man United colours, or whoever he plays for these days, then that would not be personalised sufficiently for them to lose the right to cancel, and they would be able to exercise the right to cancel. Customers can also lose the right to cancel if they do certain things to the goods once they've received them. So, for example, if they unseal goods that have been sealed for hygiene or health reasons, then they would lose the right to cancel. Similarly, with sealed audio, video and software, if they've unsealed that audio, video or software, then again they would lose the right to cancel. And finally, on that slide, they would also lose the right to cancel if goods became mixed inseparably. So the BIS guidance gives an example of oil. So if you put something liquid into something else and the goods become mixed inseparably, then the customer would lose the right to cancel. Now, the new regulations have introduced the concept of digital content for the first time. And what you need to do if you are selling digital content, you must not supply the digital content before the end of the cancellation period, i.e. the 14 days, unless the customer has provided you with their express consent to you providing that digital content before the end of the cancellation period, and that the customer acknowledges that they are going to lose the right to cancel if you actually do that. And then the final thing that you need to do is that you need to confirm your receipt of the customer's consent and acknowledgement. And this is because otherwise, with digital content, which is downloadable immediately, customers can download it, use it, consume it, and then cancel within the cancellation period and ask for a refund. So this is to help traders with that scenario, but you do have to jump through a number of hoops to make sure that the customer loses the right to cancel. So just to repeat that, because this is fairly complex, in your terms of business, if you're selling digital content, you need to have express consent from the customer to you beginning to supply the digital content before the end of the cancellation period. You need their acknowledgement that they lose the right to cancel. And then you need to confirm their consent and acknowledgement when you confirm the contract in a durable medium. And in this instance, that will be an email once the customer has placed the order, with a PDF of the terms of business attached to that email. That's a durable medium. You can't just put in a link to a website page because that might change. So what you need to do is you need to take a snapshot of your current terms of business at the point that that customer placed an order. And the best way to do that is to form a PDF and attach that to the confirmatory email that you send once the customer has placed their order. You can only charge for return delivery if you made this clear in your terms, otherwise you must pay for return delivery. And refunds must be provided within 14 days after the day on which you received the goods back, or, if earlier, 14 days after the day on which the customer supplies evidence of having sent the goods back. And it seems fairly obvious to me, but it is in the regulations, so I will point it out. You must not charge a fee for refunding your customers. Now, you can deduct from a refund any diminution in value that's caused by excessive handling by your customer, but you can only do this if you made this clear in your terms of business. So again, do include this. Now, what is excessive handling? Well, the BIS guidance says that what is acceptable handling is what a customer might do with goods if they are actually in a store with the goods, rather than buying from distance. So they gave an example of a toaster, and the toaster had been returned to the supplier and it had crumbs in the bottom of the toaster. And BIS said that this was excessive handling. It would have been acceptable for the customer to have opened the toaster from the packaging, possibly even to have plugged it in to see whether it worked, whether it heated up, but not to have actually put toast through the toaster and then returned it with the crumbs in. So the supplier was entitled to deduct from a refund a diminution in value of that toaster. But again, just to stress, you can only make that deduction if you made that clear in your terms of business. Refunds must be made by the same method by which the customer paid, unless you've stated otherwise in your terms. And you must reimburse all delivery costs except where they chose a higher level of delivery, in which case you only need to refund them the costs of the least expensive delivery. So if, for example, you had 2 delivery levels, one was your most basic at $2.99 for delivery within 5 days, but they needed the product sooner and went for a next day delivery at $9.99, then you only need to refund them your lowest level of delivery, i.e. the $2.99. And speaking of delivery, all goods must be delivered within 30 days unless the customer agrees otherwise. And the place where they would agree otherwise is in your terms of business. So if you know that you need more than 30 days to deliver your products, then you must specify that in your terms of business. Now, if the goods aren't delivered within 30 days, if that's what you've provided for in your terms of business, and the delivery within that time was essential. And when I say essential, then that is either that the customer made it known to you that delivery within that time period was essential, or that according to all the circumstances of that case, it was apparent that delivery within that time was essential, then the customer may treat the contract as at an end and may ask for a refund, and you must, without undue delay, reimburse all payments to that customer. So what should you do now? Well, you have three options. You can either watch the next two videos, or if you know that you need to take action right now, what you can do is you can buy template terms that I'm making available at the price of £97. Or if you prefer bespoke terms of business, then do get in touch with me and I can talk you through how I can help you with bespoke terms. And my prices for those start at £697 plus VAT. So if you do want to know more about how I can help you, and if you want to get hold of one of the template terms of business, or to contact me in relation to drafting bespoke terms of business, then do get in touch. My website is www.suzannedibble.com/sellingonline, and I will look forward to hearing from you. In the meantime, I look forward to seeing you on the next video.